Welcome back to the deep dive. If you spend any time studying civil procedure, you know that the initial phase, the exchange of the plaint and the written statement of defense is really just the setup.
Exactly. Those documents, they define the boundaries of the fight, but they don't organize the actual battle.
Today, we are taking a major procedural step forward. We're moving beyond the filing cabinet and diving deep into the decisive third stage of a civil suit, pre-trial proceedings.
This is truly the moment the court stops being a passive recipient of documents and starts actively engaging with the dispute.
I see.
It's the phase where the judiciary first applies its mind, transforming a set of sometimes vague or conflicting claims into a structured, highly organized legal battle plan.
And for you, our listeners, who need to master the practical realities of procedural law, this transition is absolutely vital.
It is. It's where cases are won, lost, or, let's be honest, most often, settled.
Our mission today is laser-focused on providing you with that mastery. We're going to unpack the 6 critical procedural pillars that determine the trajectory, and often the fate, of a civil case before a single witness is ever called to the stand.
We're talking about appearance rules, examination, preliminary objections, framing issues, all the big ones.
And some of those quick adjudication mechanisms, and even how suits are discontinued.
And before we get into the weeds, we absolutely must extend our sincere gratitude. This deep dive is built entirely upon the rigorous and invaluable discussion material prepared by Mr. Abdurahman Said.
Right.
His detailed notes, perfectly tailored for you third-year law students focusing on procedural strategy, they serve as our definitive guide through this very complex legal terrain. We will be leveraging his expertise to make sure you get a forensic and comprehensive understanding of this whole process.
Our goal is to ensure that by the time we wrap up, you won't just know what happens in the pretrial phase, but why the rules are structured the way they are, and critically, how to use them strategically.
So let's jump in.
Let's jump right into the procedural traps and mandatory duties, starting with the linchpin of the entire process, the first hearing and the critical nuance of appearance.
The first hearing is often mistakenly viewed as just, another date on the calendar. But procedurally, it's the capstone of the preparation phase.
The capstone, I like that.
Its overarching objective is transformation. The court moves beyond passively collecting pleadings to actively understanding the exact contentions of the parties and framing the concrete legal and factual issues for trial.
That sounds simple, but within that one hearing, we have 4 major mandatory procedural acts.
That's right. You have the examination of parties, you have the ruling on preliminary objections, then framing issues, and finally determining if there's any potential for a quick disposal of the suit.
But before any of that can happen, the parties actually have to show up. And this brings up a crucial distinction that trips up so many practitioners, let alone students.
Oh, yes. The difference between the appearance date for the written statement of defense and the appearance date for the first hearing.
Let's break that down.
This procedural distinction is absolutely foundational. So let's look at Article 233 of the Civil Procedure Code first. This date is strictly for the defendant to appear and file or collect their written statement of defense.
So it's just administrative, purely about the document.
Exactly. The function is administrative and document-focused.
I remember the cassation insight here, that note confirming the hearing date for receiving the written statement is separate and distinct from the hearing date for the examination, which is the first hearing. Why is it so crucial that the court keeps those dates separate?
It's all about due process and proper sequence. I mean, the court cannot effectively examine parties or frame issues until all the pleadings are formally closed.
That makes sense.
If they combine the dates, the court would either have to wait while the defense is finalized right there and then, or proceed with a partial view of the dispute, which just undermines the entire purpose of issue framing.
Okay, so let's track the consequence. What happens if the defendant fails to show up on that specific Article 233 date to file their statement of defense?
This is where the code gets harsh. It triggers Article 109. The court must order a default proceeding. And the immediate critical consequence is that the defendant loses the right to submit that written statement of defense.
They lose the right entirely.
They forfeit their primary opportunity to formally structure their defense in that document. It's a huge strategic loss.
That sounds brutal, but if the defendant can still participate later, how is that loss of right, reconciled?
It's a procedural penalty, not a total exclusion. And that's the key. The law has to balance the need to punish procedural delay with the constitutional right to be heard.
Okay.
So the defendant is not excluded from attending subsequent hearings or cross-examining the plaintiff's witnesses or even presenting rebuttal evidence later, but they cannot formally introduce that comprehensive, written defensive structure.
So they're fighting with one hand tied behind their back.
That's a perfect way to put it. They're not entirely out of the fight, but they're at a significant disadvantage.
So what if the defendant had a genuine reason? A medical emergency, a flat tire on the way to court. Can that be mitigated?
Absolutely. Article 189(2) provides the necessary escape valve. If the non-appearance or the failure to submit the defense is due to sufficient cause, the court is under a mandatory duty to grant a further adjournment.
So the court has to give them more time.
Notice the word mandatory. The court has no discretion to refuse if the cause is proven sufficient. This really highlights the procedural protection against pure misfortune.
Now, let's pivot to the appearance required at the first hearing itself. This is where the consequences for not showing up get far more severe.
The procedural stakes are much higher because this date involves judicial action examination and issue framing, not just filing a document. Article 69 mandates that both the plaintiff and the defendant must appear either personally or through an authorized representative.
And I find it fascinating that the court has this reserve power to demand personal appearance, even if a pleader is present. Why is that judicial power so important at this specific stage?
Because the court needs to examine the parties to clarify vague facts or secure crucial admissions. A pleader, while an expert in the law, might not have that direct, first-hand factual knowledge.
So they need the actual person involved.
Right. If the court deems personal appearance necessary, say, to verify the identity of a signatory on a key contract, and that party fails to show up without a good reason, Article 77 treats that failure as no appearance at all.
And that triggers the most severe consequences.
Exactly. It triggers the consequences detailed in Article 32.
The source material really emphasized that when non-appearance occurs, the court has no discretion to simply adjourn. This mandatory action seems to be the core of procedural rigor.
It is. Procedurally, the judge is forbidden from just saying, I'll deal this next week.
Why so strict?
Because delay undermines the entire system of prompt justice. Article 32 ensures that every procedural failure is met with an immediate mandatory response. And the action taken depends entirely on three factors: who failed to show up, why they were summoned, and the nature of the suit itself.
Okay, so let's map out the three critical outcomes based on who is missing at that first hearing.
Let's do it.
Start with the most frustrating one for the court. The lawyer sleeps in, the clients are absent, and both parties fail to appear.
Article 69(2) applies. The suit shall be struck out. If this were an appeal, the appeal would be dismissed.
And struck out means the case is just removed from the docket for now, right? The cause of action isn't necessarily dead.
Precisely. We'll get to the remedies, but that's the general idea.
Okay, next scenario. The defendant shows up, ready to argue, but the plaintiff fails to appear.
Art 73 dictates that the suit shall be dismissed. This is a far more serious consequence for the plaintiff.
Because dismissal generally prevents them from refiling the suit.
It can lead to the loss of the right to action on the merits. It's a very serious outcome.
And the reverse. The plaintiff is there, ready to go, but the defendant is a no-show.
This triggers Article 70A, which leads to an ex parte proceeding, provided, and this is a huge caveat, that the summons was proven to be duly served. Now, here is a pivotal point for you as law students to remember. An ex parte order does not mean the plaintiff wins automatically.
Okay, that's crucial.
The court must still hear the plaintiff's evidence and be satisfied that the plaintiff has successfully made out a legal case for the relief they're requesting. The non-appearance removes the defense's active participation, but it does not remove the plaintiff's burden of proof.
Let's really nail down the critical differences in the remedies here, because the stakes are defined by whether the suit is struck out or dismissed.
Okay. When a suit is struck out, which usually happens for failure to take a necessary step, or when both parties are absent, the plaintiff can typically file a fresh suit on the same cause of action.
So what's the penalty?
The penalty is primarily financial. They have to pay another court fee unless they can prove a sufficient cause for the initial non-appearance. It's an inconvenience, a hassle, but it's not a catastrophe.
But the effect of dismissal, which happens when the plaintiff is absent and the defendant is present, is catastrophic.
It is. Dismissal prevents the plaintiff from bringing a fresh suit on the same cause of action. It could lead to the permanent loss of the right to action itself, unless they successfully navigate the appeal or the set-aside process. The stakes could not be higher for the plaintiff in making sure they appear.
But both parties, whether they've suffered a dismissal or an ex parte decree, have a procedural lifeline, an application based on good or sufficient cause.
Yes. The time limit is 1 month. For the plaintiff, it's 1 month from the date of dismissal. For the defendant, it's 1 month from the date they became aware of the ex parte decree.
Which brings us to that pivotal and often vague legal standard, sufficient cause.
This is the subjective standard that judges spend their entire careers defining. It is entirely case-by-case and context-dependent. The best way for students to think about it is to look at the effect of the failure.
Okay, so if the consequence of the non-appearance is just procedural, like having to pay a new court fee because the suit was struck out, how is the standard applied?
In that case, the standard for sufficient cause must be strictly construed. The court assumes the party should have been diligent.
So you need a really good excuse.
You do. Only factors clearly beyond human control, like a court notice being delivered to the wrong address despite the client providing the correct one, will usually suffice. The penalty, the court fee, is relatively minor, so the bar for the excuse is high.
But if the consequence is catastrophic, destroying a party's substantive right, like a dismissal or an ex parte decree that denies a defense, the standard must shift.
It absolutely must shift to protect the constitutional right to access justice. In that scenario, sufficient cause must be construed liberally. We are looking for good faith and plausible misfortune.
And the cassation bench has provided guidance on this.
Yes, there's a case note that confirms this approach, instructing that sufficient cause must be interpreted by considering the defendant's good faith and various relevant factual circumstances. This acknowledges that the loss of a substantive right due to a procedural slip must be treated with judicial mercy, provided the party wasn't just being indifferent or negligent.
Can you give us a practical example of something that would qualify under that liberal construction?
Certainly. Imagine a defendant who missed the first hearing because they were traveling for essential business and their pleaders suffered a sudden documented hospitalization.
Okay.
Now, one could argue the defendant might have been able to hire a second pleader, but the court, applying the liberal standard, would likely find that the confluence of unexpected events and the clear good faith, the defendant hired a pleader in the first place, qualifies as sufficient cause to set aside the ex parte decree.
And on the flip side, what kind of behavior does the law explicitly not reward?
Indifference, callousness, bad faith, or willful disregard. If the defendant failed to appear simply because they forgot the date, or they were trying to deliberately delay the proceedings, or they used a transparently false excuse, the law will not grant a remedy. The law is designed to manage misfortune, not to reward negligence.
All right, assuming the parties are present, we move into the first mandatory judicial activity of the first hearing, the examination of parties under Article 241. This is not a trial, it's more like triage.
That's a great term for it. The court's primary duty is to verify identities, read the pleadings aloud, and then engage in a crucial dialogue with the parties or their pleaders.
And the core of this is what?
The core of this is extracting specific admissions and denials regarding the allegations of fact. This links back directly to the procedural rule, which requires specific denial in the written defense. If the written defense was vague, the examination forces clarification.
I see three clear purposes for this process in the source material. The first one seems obvious, ascertaining the matters that are truly in controversy.
Exactly. If a defendant admitted in the written defense that they owed 100,000 birr, but disputed the remaining 50,000 birr, the court will confirm that admission. That 100,000 birr is now a settled fact. No evidence will be required on it. The controversy is narrowed.
The second purpose is to clean up sloppy drafting, elucidating what is obscure or vague in the written pleadings.
This is so critical in practice. Pleadings can often contain legal conclusions disguised as facts, or just blanket statements like, all claims are denied. The court uses the examination to cut through that rhetoric and ask pointed questions.
Right.
Did you or did you not sign the contract on this date? Yes or no? It transforms ambiguity into clarity.
And the third purpose is foundational for the next stage, assisting the court in clarifying and developing the issues for trial.
Yes. The admissions and denials secured during the examination are the raw material for framing the issues later on. The court needs to know what the parties agree and disagree on to properly define the fight. The cassation bench supports this, stating that Article 241's primary aim is to clarify written arguments and help frame issues.
And that cassation insight also carries a crucial limitation, doesn't it?
It does. The court reiterated That Article 241 does not authorize parties to introduce new judicial claims or new causes of action that were not contained in the written application.
So you can't use the examination to spring a surprise cause of action on the other party?
No, absolutely not. The scope of examination is strictly limited to refining the existing claims and defenses.
So let's discuss the power of admissions made here. If they are secured during the examination, are they as binding as those made in the written statement of defense?
They are conclusive. This is why the examination process is so high stakes. An admission made at the first hearing settles the facts forever. No issue will be framed on admitted matters, and no evidence needs to be presented.
So strategically, a lawyer needs to prep their client very carefully for this.
Oh, absolutely. Especially if the client is ordered to appear in person. You have to make sure they do not accidentally admit a fact that's vital to their defense.
And the court controls this entire process. Why is the rule so strict that the examination must be court-conducted and cross-examination is prohibited?
Because the court is acting in an inquisitorial fact-finding capacity at this stage. It's not adversarial yet.
I see.
The goal is procedural clarity. Allowing cross-examination would immediately transform the first hearing into a mini-trial, requiring witnesses and evidence, which would defeat the entire purpose of this preparatory phase. The court can ask questions suggested by either party, but the judicial control remains absolute.
A vital efficiency mechanism that comes out of this examination is Article 242, allowing for partial admission and judgment. Can you walk us through a common scenario where this applies?
Of course. Imagine a suit for the return of land and, say, damages for 2 years of lost rent. The defendant admits, yes, I possess the land and I agree the plaintiff is the rightful owner, but I strongly disagree with their calculation of 500,000 birr in damages.
So liability is admitted, but the quantum, the amount, is disputed.
Exactly. The court does not wait. It issues a judgment immediately on the admitted part, the return of the land to the plaintiff. Then it frames issues only on the denied facts, the precise quantum of damages, and the case proceeds to trial only on that single remaining issue.
That's a fantastic example of judicial efficiency. It gives the plaintiff immediate relief on the undisputed part.
And it dramatically narrows the scope of the full trial. It's a win-win for court efficiency.
Okay, so if the parties are present and the court has examined them, the next logical step is to determine whether the case is even fit to proceed in this particular forum. This brings us to preliminary objections, the gatekeepers of the judicial process.
POs are procedural landmines. Strategically, they are points of law or fact that, if successful, can terminate or pause the proceedings. But critically, they do not touch upon the substantive merits of the claim.
So it's not about whether the defendant is liable.
Correct. It's not about liability under the Civil Code. A successful PO means the court simply cannot or should not proceed any further with the case as it stands.
The grounds listed under Article 244(2) are expansive, and the sources confirm the list isn't even exhaustive. Let's make sure our listeners have a detailed understanding of the key categories.
We can break them down into 3 main groups. First, you have jurisdictional or authority defects. This includes lack of material, local, or judicial jurisdiction.
So if a court just doesn't have the power to hear the case?
Right. If the court lacks the fundamental power to hear the subject matter, which is material jurisdiction, or the physical location of the dispute, local jurisdiction, or if the judge is inherently disqualified, which is judicial jurisdiction, the suit cannot stand.
Okay, what's the second group?
The second group is about issues of prior resolution or pendency. This covers res judicata, meaning the matter has already been definitively decided between these parties.
So you can't sue twice for the same thing?
In essence, yes. And it also covers when a suit is pending, meaning the same matter is already being litigated in another court. The policy here is about the finality of litigation and preventing simultaneous conflicting judgments.
And the third group covers the capacity of the parties or other preconditions.
That's right. That includes incapacity or not being qualified for acting. For example, an unrepresented minor or an insane person. It also covers failure to obtain prior permission when the law requires it.
Like what?
A classic example is from the Commercial Code, which requires shareholder approval before suing a company director. We also include issues like the suit being barred by limitation, and finally where the claim was already settled by arbitration or compromise.
Procedurally, there's a strict duty on the defendant. The objection has to be raised at the earliest possible opportunity, in the written defense or at the first hearing. What happens if a lawyer misses that window?
If the lawyer fails to raise it, the objection is deemed waived. They lose the right to argue it later. This forces procedural diligence.
But, and this is a huge but, there are exceptions.
A pivotal distinction. Certain objections are so fundamental to the integrity of the judicial process that they cannot, under any circumstances, be waived.
The sources identified 4 of these unwaivable grounds. Let's spend a moment reinforcing why these specific 4 are treated as foundational exceptions.
They relate directly to the power of the court or the inclusion of essential parties. Material jurisdiction is non-waivable because a court cannot give itself jurisdiction just because the parties agree to it.
Right. You can't consent to an invalid process.
Exactly. If a low-level court is trying a case explicitly reserved for the Supreme Court, any judgment it renders is inherently invalid.
Okay, how about pendency?
If the same suit is pending in another court, allowing the second case to proceed risks judicial chaos and conflicting judgments. This is a matter of state efficiency and judicial priority. It can't be waived.
Incapacity.
This is about protecting the vulnerable. If a party lacks the legal capacity to act a minor, for instance, they are procedurally unprotected. The court has a mandatory duty to address this, whether the other side raises it or not.
And the last one, failure to join an indispensable party.
Right. You cannot give a valid judgment if a necessary third party, whose rights would be directly impacted by the outcome, is absent from the suit. Think of a joint ownership dispute. You can't decide who owns the property if one of the joint owners hasn't been brought into the case.
So conversely, if a defense attorney is relying on res judicata or a problem with local jurisdiction and they missed that first hearing deadline, those rights are gone forever.
Yes, those are waivable. The logic is that if you don't object to local jurisdiction, you're implicitly consenting to that location as the forum. If you don't object to res judicata, you're essentially saying, fine, let's proceed to a new trial on the merits. Law students must internalize this distinction. Missing a waivable PO is malpractice.
Once a PO is raised, Article 245 mandates a specific court procedure. The judge can't just make a quick decision.
No, the court cannot be arbitrary. It must hear the opposite party. And critically, if the objection requires some kind of factual verification.
Like proving where the defendant lives for local jurisdiction.
Exactly. The court must order the necessary evidence. The judge has to render a definite, reasoned decision on the objection.
And the procedural consequence of this decision is perhaps the most shocking detail. It is not appealable.
That procedural finality is really something. It underscores the gatekeeper function of the PO. The law deems that these are procedural rulings on the admissibility of the case, not judgments on the merits, and they have to be accepted immediately to ensure the flow of the judicial process.
So if a court wrongly dismisses your case based on limitation, you can't appeal that PO ruling right away.
Not through an immediate appeal of the PO ruling itself. Your only recourse is usually to challenge that procedural decision as part of an appeal of the final judgment, if the case ever gets there, or through other extraordinary means.
Now let's tie this back to our earlier discussion on the consequences of non-appearance. The 2 outcomes of a successful PO are dismissal versus strikeout.
The distinction depends entirely on the possibility of filing a fresh suit. Dismissal means the suit cannot be instituted afresh because the plaintiff has no legal right to pursue it again.
And this is reserved for things like res judicata and limitation.
Precisely. If the statute of limitation has run out, the cause of action is legally extinguished. Dismissal is the appropriate final disposition.
Strikeout, on the other hand, implies that the plaintiff has a chance to fix the error.
Correct. Strikeout is applied when the plaintiff retains the opportunity to refile or continue the case elsewhere. This applies to lack of jurisdiction, where you can just refile in the correct court, or incapacity, where you can find a legal representative, or lack of permission, where you can go get the necessary permission.
And there's even that fascinating detail about a court fee refund if the suit is struck out for lack of jurisdiction.
It is fascinating. It's an acknowledgement that if the court lacked the power to hear the case from the start, it shouldn't really retain the full fee. While practice varies, there's a historical precedent suggesting a partial reduction, maybe 10%, to cover administrative costs, while refunding the bulk of the fee to the plaintiff who just chose the wrong forum in good faith.
All right. Assuming the suit survives the preliminary objections, we enter the strategic heart of the pretrial phase. The framing of issues. The pleadings, the plaint, and defense might lay out the claims, but the issues define the exact questions the court will answer.
Precisely. Issues are the material propositions of fact or law that are affirmed by one party and denied by the other. They are the disputed questions that need a judicial determination. The importance of this stage, it cannot be overstated.
A material proposition being something you have to prove to establish a right or a defense.
Yes. If Party A asserts the contract was breached and Party B denies it, that is a material proposition and it becomes an issue of fact.
And we must distinguish clearly between the two kinds of issues.
We must. You have issues of fact, which are points of controversy requiring evidence to determine what happened, who said what, when did the damage occur, what was the market value,
And issues of law.
which concern the legal implication of undisputed or proven facts. For example, did the facts that we've all admitted to constitute force majeure under the Civil Code?
Article 245 makes framing and recording issues mandatory unless there's no defense. From a strategic perspective, why is this mandatory for the court?
It provides focus and fairness. First, it streamlines the dispute. Second, it prevents ambush or surprise at trial because both parties are fully aware of what they need to prove. Third, and this is most critical for you as law students, the issues that are framed are the exclusive guide for the parties in adducing evidence.
So if you prepare evidence for a fact, that isn't part of a framed issue.
You risk having that evidence deemed irrelevant by the court. It's a waste of time and money.
So the court must be thorough in its preparation. Article 248 mandates that the court has to draw its issues from 3 defined sources.
Yes. The allegations in the pleadings, so the plaint and defense, the contents of any documents produced by either party, which might contradict the pleadings, and finally, the oral allegations and admissions made by the parties during that examination we discussed earlier.
So the issues are a synthesis of all these elements.
Exactly, to ensure no disputed point is missed.
And to make sure that synthesis is robust, Article 249 gives the court power to acquire more materials before it frames the issues.
The court has to satisfy itself that it has enough information to properly define the contest. This means the court can order the production of documents that are still outstanding or even conduct a special examination of a person who's not yet before the court if their testimony is required to clarify the scope of the dispute.
Can you give an example of that?
Sure, imagine a boundary dispute where the court needs to commission a land surveyor. That step has to be taken before the issues are framed to ensure the resulting issues are based on accurate physical boundaries.
Once issues of law and fact exist, how does the court strategically manage the order of trial? Article 2474 seems like an efficiency rule here.
It is a massive potential time saver. If the court determines that the case might be resolved entirely on the issues of law alone, it shall try those issues of law first.
So if the core issue of law is whether the plaintiff's claim, even if factually true, is barred by sovereign immunity,
the court should rule on immunity first. If immunity is established, there is zero need to spend weeks hearing evidence on the disputed facts of negligence or damages. The court can then postpone all the issues of fact until that legal determination is made.
this inherent flexibility is mirrored in Article 251, which allows for additional issues and corrections, even after the initial framing.
Litigation is dynamic. The trial itself can reveal new, unexpected points of dispute. The court retains the power to frame additional issues at any time before judgment if it's necessary to determine the real question in dispute. This often happens if the court initially missed an issue, or if an amendment to the pleadings is permitted later on.
But there have to be limits on introducing new issues. It can't be a free-for-all.
There are limits.
Yeah.
The court is explicitly cautioned against framing a new issue that introduces a technical point the defendant had already waived, like that local jurisdiction objection they forgot at the first hearing.
So it can't be used to undo a procedural waiver.
Correct. Nor can it be used to take away a right that's accrued by lapse of time, like suddenly raising a new limitation defense on its own motion. The purpose is to protect accrued procedural rights. And of course, the court also has the complementary power to strike out issues that were wrongly framed in the first place just to keep the battleground precise.
Judicial economy is a cornerstone of any modern legal system. This next section details 3 distinct mechanisms in the CPC designed to adjudicate cases in whole or in part without the need for a full, costly, and time-consuming trial. These are essential tools for an effective lawyer.
They're critical procedural exits. The court would always prefer to avoid the full machinery of trial witness testimony, cross-examination, lengthy evidentiary processes, if the dispute can be resolved sooner.
The first and most unusual is the agreement on issue. This is entirely party-driven.
This is a very sophisticated mechanism that presupposes a degree of cooperation between the parties. It's an exception to the rule that the court must frame the issues. It allows the parties, after looking at the pleadings, to agree that only a single question of fact or law remains in dispute.
And the mechanism is unique because the parties essentially write the judgment beforehand.
They do. They state the question in the form of an issue, and they enter into a detailed written agreement stipulating that the court's finding affirmative or negative will automatically trigger a specific predetermined judgment. For instance, if the court finds the price of the goods was 10,000 birr, defendant pays 5,000 birr. If not, the suit is dismissed and plaintiff pays costs.
The court's role, though, isn't just to rubber stamp this agreement. What must it verify?
The court has to verify procedural propriety. It checks that the agreement was duly executed, signed, and witnessed. It checks that the parties have a substantial interest in the decision, so this isn't a moot or theoretical point. And it checks that the question is fit to be tried.
And if the court is satisfied?
It then tries only that single issue, records its finding, and pronounces judgment precisely as the parties pre-agreed.
We noted the complex situation regarding the right to appeal this judgment. It's a bit of a gray area.
It is genuinely debated. In our legal tradition, appeal is a constitutional right. However, if parties voluntarily agree that a finding on a single issue will result in a judgment based on their pre-agreed terms, well, does appealing that final judgment not undermine the initial contract of the agreement itself?
So it's a conflict between contract and constitutional right.
In a way. The CPC doesn't explicitly bar appeal here, unlike with compromise, which we'll cover shortly. So practitioners often argue that since the court made a judicial finding on the issue, the right to appeal that finding should be preserved.
Let's move to the second and arguably more powerful mechanism for quick resolution. Parties not at issue. This is a judicial determination, not a party agreement.
This triggers when, at the first hearing, it becomes apparent to the court that the parties are not at issue on any question of law or of fact, despite their nominal disagreement. If there's no genuine, legally cognizable dispute, the court pronounces judgment immediately.
This requires specific illustration because students often confuse this with simple admissions. This is really about legal sufficiency. Can you walk us through some of those critical scenarios?
Let's start with a legally insufficient defense. A defendant is sued for debt and admits receiving the money. But his defense is that the interest rate he was charged was too high, according to his personal view, without citing any specific law.
So his defense has no legal basis.
Exactly. Since his defense is legally meritless and the facts are admitted, the parties are not at issue on liability. Judgment is entered for the plaintiff.
Or what about internal contradiction in the defense?
This is often overlooked. If a defendant in a contractual dispute pleads, "I never signed the contract," but then in the same defense pleads, "And even if I did sign it, force majeure excuses my performance," the second defense potentially admits the existence of the contract.
Ah, I see. It's self-defeating.
Potentially. If the facts brought out during the examination confirm that second self-defeating argument, the court may find the parties are not at issue on the formation of the contract.
And the case of purely conclusory defenses.
If the written defense contains only legal conclusions, like the plaintiff's claim is void or I reject all liability, and the party refuses or is unable to provide any factual substantiation during the oral examination, the court has to resolve all doubts in favor of the plaintiff and find that no genuine issue of fact exists.
And finally, we noted the importance of the plaintiff's own procedural diligence regarding affirmative defenses.
Yes, if the defendant raises a clear, valid affirmative defense, like the statute of limitation, and the plaintiff fails to deny the applicability of that limitation, the defense is deemed admitted by silence.
And so the claim is barred and the parties are not at issue.
Correct. The court may dismiss the suit right there under Article 254.
The safeguard here, resolving all doubts in favor of finding an issue, is essential to prevent abuse of this powerful mechanism.
It is. It ensures this provision isn't used to arbitrarily deny someone a trial. Termination should only occur if it is absolutely clear that no question of fact or law remains in dispute. And the court can use this mechanism partially, too.
Meaning?
If one defendant admits everything, but a second defendant maintains a valid defense, judgment is pronounced against the non-disputing defendant, and the suit simply proceeds against the second.
The third mechanism, deposition of issues at the first hearing, differs because here, issues do exist and have been framed.
This is for cases where issues exist, but the court is satisfied that no further argument or evidence is required, and crucially, that no injustice would result from rendering judgment immediately. The key difference from the last one is that this only applies after issues are framed.
When is this appropriate?
It is perfectly suited for pure issues of law, where interpretation of a statute or a contract clause is all that's needed, and the relevant documents are already in the file. It's also suitable for issues of fact that rely exclusively on documentary evidence that's already been submitted.
Like, if the only issue is whether a bank guarantee was delivered by a certain date and the dated receipt is in the file.
Perfect example. The court can decide that immediately.
But the source material cautions that this is not a substitute for a trial involving oral evidence. Why is that?
Because a full trial with conflicting oral evidence requires the court to assess witness demeanor, credibility, and consistency over time. Furthermore, the process to summon all the necessary witnesses happens after the first hearing. If the issue requires testimony, this article can't guarantee fairness, as the court would be deciding based on incomplete evidence. It must only be used if the evidence available right then is conclusively sufficient.
Our final section covers the ways a suit can be discontinued outside of a judicial decision on the merits, starting with the favored route, compromise. This mechanism elevates harmony over adversarial victory.
Compromise, as defined by the Civil Code, is a contract terminating an existing dispute or preventing a future one through mutual concessions. It's a give and take, designed to avoid the expense and emotional turmoil of litigation. The Code actively encourages it.
And we must highlight the scope distinction between the Civil Code and the CPC for our law students.
We must. The Civil Code covers compromise made before and after a suit is instituted. The CPC governs only those made after a suit has been filed, focusing on the procedural step of recording the agreement and entering judgment.
A fascinating nuance is that the compromise can settle matters not directly related to the current suit.
Absolutely. A compromise agreement can incorporate entirely unrelated matters, provided these matters form part of the mutual exchange. For instance, in a debt suit, the defendant might agree to pay the debt in full if the plaintiff, in return, agrees to drop a separate unfiled property claim.
So it encourages a total peace between the parties.
Yes, preventing future litigation on interconnected disputes.
Let's detail the procedure under Article 277 for an in-court compromise.
It must be reduced to writing and signed by the parties or their pleaders. The court's check is limited, but crucial. It must ensure the terms are not contrary to law or morals. If the compromise involves illegal activities or immoral transactions, the court has to reject it.
But what is not the court's business to check?
The court is explicitly not required to check for the fairness or reasonableness of the concessions, since it's a contract freely entered into. Even if one party concedes way more than they might have lost at trial, the court respects their contractual autonomy, as long as the agreement is legal.
And the effect of a judicially recorded compromise is finality.
Total finality. A compromise recorded by the court has the force of res judicata without appeal. This means it is as binding as a final court judgment, but without the possibility of seeking review in a higher court.
But this finality can be invalidated under very narrow circumstances.
Only if there is a fundamental mistake relating to the void nature of the agreement, such as relying on false or forged documents, or if the parties compromised a dispute that had already been settled by a prior unknown judgment. It has to be a fundamental error.
And there's a special protection afforded to minors in these situations.
Yes. A tutor needs explicit court authorization to compromise a minor's interests if the value exceeds 1,000 birr. This procedural step ensures the court acts as a guardian, preventing anyone from disposing of a significant portion of the minor's estate.
Moving to our final procedural mechanism, withdrawal or abandonment of suit. This is the opposite of compromise, a unilateral decision by the plaintiff. And we have two critical types, with leave and without leave.
Withdrawal with leave is when the plaintiff asks the court's permission to institute a fresh action later. The court will grant this only under two strict conditions. If the suit is bound to fail due to a formal defect, like a misjoinder of parties, or if there are other sufficient grounds for allowing a fresh action.
Why is the standard for granting leave so strict?
It's purely to protect the defendant from harassment. If leave was easy to get, a plaintiff could file a case, withdraw it when the defendant incurs costs and files a defense, and then just refile again indefinitely. The law strictly construes this exception to protect the defendant.
And the consequence if leave is granted.
The plaintiff is permitted to institute a fresh action, but, and this is vital, they remain bound by the law of limitation as if the first suit had never been filed. The original filing date does not pause the limitation period.
Now, what if the plaintiff withdraws without leave, or if the court denies leave and they withdraw anyway?
This is withdrawal without leave. The consequence is punitive. The plaintiff is liable for costs, and they are precluded from instituting any fresh suit on the same subject matter or claim. This is a permanent bar on refiling that specific lawsuit.
But there's a procedural distinction often exploited here regarding the claim itself.
Yes. The preclusion applies to the same claim. If a plaintiff files a suit based on a claim of tortious negligence and withdraws without leave, they are precluded from refiling that negligence claim. However, they might still be able to institute a fresh suit on the same subject matter, but with a different claim, say, a contract claim arising from an insurance policy covering the same accident. It's a narrow loophole.
Finally, a quick mention of Article 280, extinction of cause of action. This is unique because it's court-initiated.
If the court becomes satisfied at any stage that the underlying cause of action has ceased to exist, say, the subject of the dispute has been legally expropriated, or a death has occurred that extinguishes the claim, the court shall dismiss the suit. The cassation bench highlights that the court must act whenever it's clear the reason for the claim has vanished.
We have completed a comprehensive tour of the pretrial phase, moving from the strict mandatory duties of appearance all the way through to the strategic exit mechanisms of compromise and withdrawal. What stands out to me is the immense pressure this phase places on the lawyer to be procedurally precise.
That precision is key. We've seen how mastering the distinction between struck out and dismissed determines the future of a client's claim, and how interpreting sufficient cause hinges on whether a substantive right is at stake. The pretrial phase is where a good lawyer ensures the case is clean, organized, and focused only on the true controversy.
These procedural requirements are not arbitrary burdens. They're the engine of judicial efficiency, ensuring that the trial stage, with all its cost and time, is reserved for disputes that genuinely require it.
And this leads us to our final thought for reflection. The pretrial phase demands strategic rigor, but it also reflects a balance of priorities. Consider the unappealable nature of a preliminary objection decision.
Right.
Does this seemingly harsh rule, which prioritizes judicial efficiency, truly undermine the fundamental right to appeal a substantive decision? Or, by forcing immediate issue resolution, does it ultimately safeguard against a greater injustice, a trial wasted on a flawed legal premise?
It's a crucial question about efficiency versus fairness, one that procedural law students must always keep in mind. Food for thought, indeed. Thank you for joining us for this deep dive into decoding civil pretrial proceedings.
My pleasure.
We'll see you next time.